Breaking news: the U.S. Supreme Court has just dropped a bombshell decision that could reshape birthright citizenship in America, leaving the nation grappling with a potential patchwork of laws. This is a major development that could trigger widespread confusion and legal battles across the country. Supreme Court partially limits injunctions on Trump's birthright citizenship order. In a 6-3 majority decision, the U.S. Supreme Court has partially stayed the injunctions against President Donald Trump's executive order aimed at curtailing birthright citizenship. While the government's request for stays was granted, it was limited to injunctions that were broader than necessary to provide complete relief to individual plaintiffs with standing. This means federal judges will have less power to issue nationwide orders. What does this mean? A potential patchwork across the states. This ruling creates a complex legal landscape. Here's how it breaks down. For individual plaintiffs who challenged the order, lower courts cannot issue nationwide injunctions. Their relief is now limited to a determination that their children would be U.S. citizens. This is a significant shift. However, for states that sued, the Supreme Court did not decide whether a nationwide injunction is necessary to give them complete relief. This crucial question has been sent back to the lower courts for further determination. This split approach could lead to a patchwork result, where birthright citizenship rules might differ dramatically from state to state. Imagine a scenario: if a New Jersey resident, a plaintiff state, gives birth to a child of undocumented immigrants in Pennsylvania, a non-plaintiff state, the child's citizenship status could be uncertain. This ambiguity is precisely what concerns state attorneys general, highlighting the potential for widespread confusion and chaos. Hospitals, parents, and state agencies could face unprecedented challenges. Implementation delayed, litigation expected to soar. The executive order itself includes a 30-day period for the administration to develop implementation guidelines. This period, according to the Solicitor General, has not yet begun because lower courts had previously enjoined the order. This means there will be at least a 30-day buffer before the order could take effect, allowing time for lower courts to wrestle with whether states can secure nationwide relief. However, expect a surge in legal battles. With nationwide injunctions no longer available for individual plaintiffs, similar cases are likely to be filed in numerous federal judicial districts across the country, inviting a significant increase in litigation. This could lead to a legal quagmire, burdening our court system. Fierce dissents from Democratic appointees, existential threat to rule of law. The court's decision was met with strong dissents from its Democratic appointees, who voiced grave concerns about the implications for the rule of law. Justice Ketanji Brown Jackson called the court's decision an existential threat to the rule of law. She argues it undermines the judiciary's role. Justice Sonia Sotomayor argued that no right is safe in the new legal regime the court creates, accusing the court of being complicit in a grave attack on our system of law. She believes the court rewarded the administration's gamesmanship. They contend that the Republican-appointed justices have stripped lower courts of a powerful tool to hold administrations accountable, potentially allowing illegal policies to be implemented in areas where they haven't been challenged. They emphasize that if any case warranted nationwide relief, it would be one concerning birthright citizenship, where uniform rules are critical to prevent chaos. This ruling certainly ignites a contentious debate about judicial power and the future of immigration law.